Losing a loved one is undeniably one of the most difficult experiences we face. Amidst the grief of honoring their memory, families are often confronted with a daunting question: what happens next? While trying to navigate an emotional loss, the reality of settling their earthly affairs quickly sets in. You might find yourself staring at a stack of paperwork or a last will and testament, wondering how to legally handle their assets. This is where a legal process known as probate comes into play. It is a term many have heard, but few fully understand. Today, we are going to break down exactly what probate is and when it is legally required. Losing a loved one is an incredibly emotional experience, and the legal responsibilities that follow can feel overwhelming. You might have heard the term probate thrown around, but what exactly does it mean? In simple terms, probate is the legal process of validating a deceased person's will, settling their outstanding debts, and distributing their remaining assets to the rightful heirs. Think of probate as the formal framework that ensures everything is handled properly under the watchful eye of the law. It provides a structured timeline and court supervision to make sure creditors are paid and beneficiaries receive what they are legally entitled to. Now, the probate process generally handles two main scenarios. First, there is a testate estate. This happens when someone passes away with a valid will in place, clearly outlining their wishes. On the flip side, we have an intestate estate. This occurs when someone passes away without a will, leaving it up to state laws to determine exactly how their assets will be divided among surviving family members. While the term sounds heavily bureaucratic, probate is ultimately about people. It brings together family members, appointed executors, and often specialized attorneys. Together, they navigate a complex web of paperwork, financial records, and legal filings to honor the legacy of the person who passed away. So, when exactly does probate become mandatory? Generally, it boils down to three main scenarios. First, the deceased owned assets solely in their name. Second, the total value of their estate exceeds a specific financial threshold set by state law. And third, there are assets with no designated beneficiary. If any of these apply, the probate court must step in to legally transfer ownership. Let us look at real estate. Ownership structure is everything. If a property deed is held in joint tenancy with right of survivorship, the property automatically passes to the surviving owner, no probate required. However, if the deed lists only the deceased individual as the sole owner, the property is frozen. The only way to legally transfer that deed to an heir is through the probate process. But not all assets are subject to this legal hurdle. Certain accounts bypass probate entirely, provided they have clear beneficiary designations. For example, a life insurance policy pays out directly to the named beneficiaries, completely outside of court. Similarly, bank accounts with a payable on death, or POD designation, automatically transfer to the named individual upon presentation of a death certificate. By understanding these rules, you can see how proper estate planning keeps assets out of court. Whether it is a family boat, an investment portfolio, or a valuable art collection, moving these items from sole ownership into a living trust, or simply updating shared ownership and beneficiary forms ensures a seamless transition and saves your loved ones from the delays of mandatory probate. Now that we understand what probate is, let's look at how the process actually works. It typically unfolds in 5 main steps. First, the process begins by filing a petition with the probate court and officially appointing an executor or personal representative. Once appointed, the second step is notifying all legal heirs and known creditors about the proceedings. Step 3 involves a thorough inventory and professional appraisal of all the deceased's assets, from real estate to bank accounts. Next, in Step 4, the executor uses those assets to pay off any outstanding debts, funeral expenses, and taxes. Finally, once all obligations are settled, Step 5 is the distribution of the remaining assets to the rightful beneficiaries. A common question is, how long does this all take and how much does it cost? On average, the probate process can take anywhere from 6 months to 2 full years to complete, depending on the complexity of the estate. The costs can also be significant, typically taking up about 3 to 7% of the estate's total value in court and attorney fees, though this varies widely by state. Because the probate process is heavily paperwork-driven and strictly monitored by the court, many families choose to hire an experienced estate attorney to help navigate the complexities. Having a professional guide you through these legal steps can help avoid costly mistakes and reduce the emotional burden during an already difficult time. Since probate can be a time-consuming and public process, many people look for ways to avoid it entirely. The most powerful tool for this is a revocable living trust. When you place your assets, like your house, savings, and investments, into a living trust, they are no longer part of your probate estate. Because the trust legally owns them, they can be distributed immediately to your beneficiaries upon your passing, completely bypassing the court system. Another effective strategy is holding property as joint tenants with right of survivorship, or as tenancy by the entirety for married couples. If you own a home or a bank account jointly with someone else under these terms, full ownership automatically transfers to the surviving owner when you die. There is no need for probate intervention to make the transfer official. You can also keep your financial accounts out of probate by adding payable on death or transfer on death designations. By simply filling out a form with your bank or brokerage, you name a beneficiary to inherit the account directly. When the time comes, they only need to present a death certificate and their identification to claim the funds. Life insurance policies and retirement accounts operate the same way. What if you have a smaller estate? Many states offer a simplified procedure known as a small estate affidavit. If the total value of your assets falls below a certain legal threshold, your heirs can sign a sworn document to claim their inheritance. This avoids the traditional, lengthy probate process and allows for a much quicker resolution. Because estate laws vary significantly from state to state, there is no one-size-fits-all solution. To ensure your assets are protected and your loved ones are spared unnecessary legal hurdles, it is highly recommended to consult an experienced estate planning attorney. They can help you draft the right documents and create a comprehensive strategy tailored exactly to your family needs. Navigating the complexities of probate while dealing with the loss of a loved one can undoubtedly feel overwhelming. However, by understanding the steps of this legal process and recognizing the profound importance of early preparedness, you can significantly help ease the burden on your family during an already difficult and emotional time. Thank you so much for taking the time to watch today. We truly hope this video has provided you with clarity and comfort. For more resources and support during difficult times, please visit funeralus.com. If you found this information helpful, please like this video, leave a comment, and subscribe to our channel for more supportive content. Take care.